Okay, good morning, everybody. Good morning. Welcome, welcome. Welcome. I am had a special request to go through this indictment again at a little different time to catch some of my other followers who were unable to join me yesterday, which is completely understandable. Good morning, Larry. Welcome. So what I do is I just go through this indictment. I don't have any kind of commentary here. I am only just specifically going through the language of this indictment, just kind of walking you through the exact language. And oh yes, of course. I'm happy to take us through this again. I will just be going through again. Thanks, Sally. I'm just going to be reading through this indictment, taking you through it line by line, and explaining. Oh, sure. But I wanted to make sure I offered this at a little different time again, just for anyone who wanted to catch it live. And yes, I wish we could give it a rest. Absolutely. But I think it's important, so happy to assist where I can in as small of a way as possible here. So let me grab my coffee here, and then I will sit down and we'll kind of get going. Oh, welcome. I kind of do a little bit of everything. I have started in criminal, and I have taught constitutional law, criminal practice, along with evidence, which is my personal favorite. So I have a lot of experience and time spent going through the federal rules of evidence. That's kind of my specialty. So I feel I'm fascinated by the evidence that will be coming out. And that's really where my interest is here. So it's very interesting to see. And maybe he will be president. I mean, that's kind of up to everyone to decide if this is the candidate they want and they want to vote for. I mean, that's what we're about here. And I think if I were to say anything else, it would be against the Constitution. So I will be just going through again and explaining what the indictment says. So just one moment. And oh, absolutely, Oscar. Of course, thank you for joining. Again, I'm just walking through the indictment here. So I will be right back. Good morning, Antonio. Welcome. Okay, so I've got my coffee ready, and we can start going through this line by line again today. I will just be giving the grand jury indictment here. I've got just trying to explain to everyone so everyone can understand. Just as yes, you're welcome. Just let me know if it's out of frame or if you're struggling to see it. So far, according to what I've got on my screen, it is in frame. So just let me know if it needs to be moved or not. Topher, I don't think we're obsessed. I think this is kind of a pretty monumental moment in our history here. So, had I been around doing this at the time of O.J. Simpson, I would have done the same thing. When you have criminal indictments of this magnitude, as an attorney, I'm absolutely just compelled to talk about it. So you can feel free to go and review through my TikTok channel. I'm just all about education and trying to explain how the legal process works, making it accessible to everyone. So, all right, let's go ahead and get started. It's pretty early in the morning, so I will try to do my best. So please bear with me. All right, we've got United States versus Trump, and this is our grand jury indictment. Just as a friendly reminder, we need a probable cause in order to indict. We need proof beyond a reasonable doubt in order to convict. So those are two very different standards of evidence that we need. And so at this point, we are looking at probable cause. Now, there are 4 counts that came down. Count 1 is a conspiracy to defraud the United States, and this is where a lot of the facts and information is coming out. So we'll spend a lot of time on count 1, and then we follow that up with count 2, which is conspiracy to obstruct an official proceeding. Count 3, which is obstruction of an attempt to obstruct an official proceeding. And count 4, which is conspiracy against rights. And this is under United States Code Section 241. So, yes, I do I was able to upload last night's live onto my Tube of You channel, which is under my TikTok name as well. So if you want to go and listen to that or whatever, if you don't have time on our live today, that's absolutely fine. So, yes, we will see. And again, I have no political stance on this. I'm looking at this from purely academic. As an attorney, I'm licensed in my jurisdiction. I'm not really trying to whisper, but I did talk for several hours yesterday. So I'm just a little bit morning voice this morning, so you'll have to forgive me for that, but I will do my best. Oh, 2-tier justice system. I would say if you ever work within the justice system, I think a 2-tier is generous. I think we've got more than 2. So, yes, he is absolutely innocent until proven guilty. All right, let's dive on in then, everyone. Thank you all again for joining. All right, here we go. Indictment. The grand jury charges that at all times material in this indictment on or about the dates and at the approximate time states below. Introduction. Excuse me. Again, this is a little bit early for me, so. Number 1, the defendant, Donald J. Trump, was the 45th president of the United States and a candidate for re-election in 2020. The defendant lost the 2020 presidential election. 2, despite having lost, the defendant was determined to remain in power. So for more than 2 months following Election Day, on November 3rd of 2020, the defendant spread lies that there had been outcome determinative fraud in the election and that he had actually won. These claims were false, and the defendant knew they were false. But the defendant repeated and widely disseminated them anyway to make his knowingly false claims appear legitimate. Any highlights are what I went through last night on the live, and they're typically just elements of the United States Code sections. So any kind of highlights here are just going to the code section requirements. Okay, so knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration of the election. Number 3, the defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as seeking recounts or audits of the popular vote in states or filing lawsuits challenging ballots and procedures. Indeed, in many cases, the defendant did not pursue these methods of contesting the election results. His efforts to change the outcome in any state through recounts, audits, or legal challenges were uniformly unsuccessful. So again, just as a very friendly reminder, this is being recorded, so just so you know, any of your comments, which of course I'm pleased to have going here, are recorded in case any kind of buddy's looking. So I think if nothing else from this indictment, it's important people know that things can be recorded. So here we go. Number 4, shortly after Election Day, the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. In so doing, the defendant perpetrated 3 criminal conspiracies. So here are our counts from the different United States Code section. A conspiracy to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the federal government in violation of 18 United States Code Section 371. B. A conspiracy to corruptly obstruct and impede the January 6th congressional proceeding at which the collected results of the presidential election are counted and certified, the certification proceeding, in violation of 18 U.S. Code 1512 sub K. Freedom of speech is important, although I'm not the government, so it does not apply to me. Neither does it apply to the TikTok. C. A conspiracy against the right to vote and to have one's vote counted in violation of 18 U.S.C. 241. Each of these conspiracies, which built on the widespread mistrust the defendant was creating through pervasive and destabilizing lies about election fraud, targeted a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election, the federal government function. Count 1. Conspiracy to defraud the United States. The allegations contained in paragraph 1 through 4 of this indictment are realleged and fully incorporated here by reference. The conspiracy. From on or about November 14th of 2020 through on or about January 20th of 2021 in the District of Columbia and elsewhere, the defendant, Donald J. Trump, did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected, counted, and certified by the government. Purpose of the conspiracy. The purpose of the conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. The defendant's co-conspirators. Number 8, the defendant enlisted co-conspirators to assist him in his criminal efforts to overturn the legitimate results of the 2020 presidential election and retain power. Among these were, please keep in mind the co-conspirators are not named on the indictment. They are just numbered. This is an original reading of the indictment, as I did do yesterday, but going through it again. For those that may have missed it last night, I did have a special request to kind of go through it this morning. So, all right, A, co-conspirator 1. Excuse me. An attorney who was willing to spread knowingly false claims and pursue strategies that the defendant's 2020 re-election campaign attorneys would not. B. Co-conspirator 2. An attorney who devised and attempted to implement a strategy to leverage the vice president's ceremonial role overseeing. Yesterday I had someone offer to be my page turner for me. I should have taken them up on that. Certification proceeding to obstruct the certification of the presidential election. C. Co-conspirator 3, an attorney whose unfounded claims of election fraud the defendant privately acknowledged to others sounded crazy. Nevertheless, the defendant embraced and publicly amplified co-conspirator 3's disinformation. D. Co-conspirator 4. A Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election fraud. E. Co-conspirator 5. An attorney who assisted in devising and attempting to implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. And F. Co-conspirator 6, a political consultant who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. The federal government function. Senators come into play a little bit later. Number 9, the federal government function by which the results of the election for the President of the United States are collected, counted, and certified was established through the Constitution and Electoral Count Act, ECA, a federal law enacted in 1887. The Constitution provided that individuals called electors select the president and that each state determine for itself how to appoint the electors apportioned to it. Through state laws, each of the 50 states and the District of Columbia chose to select their electors based on the popular vote in the state. After Election Day, the ECA required each state to formally determine or ascertain the electors who would represent the state's voters by casting electoral votes on behalf of the candidate who had won the popular vote, and required the executive of each state to certify to the federal government the identities of those electors. Then, on the date set by the ECA, each state ascertained electors who were required to meet and collect the results of the presidential election. That is, to cast electoral votes based on their state's popular vote and to send their electoral votes along with the state's executives certification. Yes, I would like to know as well. I think there's a lot of speculation, but I certainly don't have confirmation. I've really only got what's in the four corners here of this indictment. Certification that they were the state's legitimate electors to the United States Congress to be counted and certified in an official proceeding. Finally, the Constitution and ECA required that on the 6th of January, following Election Day, the Congress meet in a joint session for a certification proceeding presided over by the Vice President as President of the Senate to count the electoral votes, resolve any objections, and announce the result, thus certifying the winner of the presidential election as President-elect. This federal government function, from the point of ascertainment to the certification, is foundational to the United States democratic process, and until 2021 had operated in a peaceful and orderly manner for more than 130 years. Manner and means. Number 10. The defendant's conspiracy to impair, obstruct, and defeat the federal government function through dishonesty, fraud, and deceit included the following manner and means. A. The defendant and co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to subvert the legitimate election results and change electoral votes for the defendant's opponent, Joseph R. Biden Jr., to electoral votes for the defendant. That is, on the pretext of baseless fraud claims, the defendant pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. B. The defendant and co-conspirators organized fraudulent slates of electors in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic the procedures that the legitimate electors were supposed to follow under the Constitution and other federal and state laws. This included causing the fraudulent electors to meet on the day appointed by federal law on which legitimate electors were to gather and cast their votes, cast fraudulent votes for the defendant, and sign certificates falsely representing that they were legitimate electors. Some fraudulent electors were tricked into participating based on the understanding that their votes would be used only if the defendant succeeded in outcome determinative lawsuits within their state, which the defendant never did. The defendant and co-conspirators then caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6th. C. The defendant and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome, that sought to advance the defendant's fraudulent elector plan by using the Justice Department's authority to falsely present the fraudulent electors as a valid alternative to the legitimate electors, and that urged on behalf of the Justice Department the targeted states' legislatures to convene to create the opportunity to choose the fraudulent electors over the legitimate electors. D. The defendant and co-conspirators attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. First, using knowingly false claims of election fraud, the defendant and co-conspirators attempted to convince the vice president to use the defendant's fraudulent electors, reject legitimate electoral votes, and send legitimate electoral votes to state legislatures for review rather than counting them. When that failed, on the morning of January 6th, the defendant and co-conspirators repeated knowingly false claims of election fraud to gathered supporters, falsely told them that the vice president had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceeding and exert pressure on the vice president to take the fraudulent actions he had previously refused. E. After it became public on the afternoon of January 6th that the vice president would not fraudulently alter the election results, a large and angry crowd, including many individuals whom the defendant had deceived into believing the vice president could and might change the election results, violently attacked the Capitol and halted the proceeding. As violence ensued, the defendant and co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification based on those claims. The defendant's knowledge of the falsity of his election fraud claims. 11. The defendant, his co-conspirators, and their agents made knowingly false claims that there had been outcome determinative fraud in the 2020 presidential election. These prolific lies about election fraud included dozens of specific claims that there had been substantial fraud in certain states, such as the large number of dead non-resident, non-citizens, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. These claims were false, and the defendant knew that they were false. In fact, the defendant was notified repeatedly that his claims were untrue, often by the people on whom he relied for candid advice on important matters, and who were best positioned to know the facts, and he deliberately disregarded the truth. For instance, A, the defendant's vice president, who personally stood to gain by remaining in office as part of the defendant's ticket, and whom the defendant asked to study fraud allegations, told the defendant that he had seen no evidence of the outcome determinative fraud. The senior leaders of the Justice Department, appointed by the defendant and responsible for investigating credible allegations of election crimes, told the defendant on multiple occasions that various allegations of fraud were unsupported. C, the Director of National Intelligence, the defendant's principal advisor on intelligence matters related to national security, disabused the defendant on the notion that the intelligence community's finding regarding foreign interference would change the outcome of the election. D, the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, CISA, whose existence the defendant signed into law to protect the nation's cybersecurity infrastructure from attack, joined an official multi-agency statement that there was no evidence any voting system had been compromised, and that declared the 2020 election the most secure in American history. Days later, after the CISA director, whom the defendant had appointed, announced publicly that the election security experts were in agreement that claims of computer-based election fraud were unsubstantiated, the defendant fired him. Just looking at the comments here. Interesting. E, senior White House attorneys selected by the defendant to provide him candid advice informed the defendant that there was no evidence of outcome determinative election fraud and told him that his presidency would end on Inauguration Day on 2020. F, senior staffers on the defendant's 2020 re-election campaign, whose sole mission was the defendant's re-election, told the defendant on November 7th of 2020 that he had only a 5 to 10% chance of prevailing in the election, and that success was contingent on the defendant winning ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, the defendant lost in Arizona, meaning he had lost the election. G, state legislators and officials, many of whom were the defendant's political allies, had voted for him and wanted him to be reelected, repeatedly informed the defendant that his claims of fraud in their states were unsubstantiated or false, and resisted his pressure to act based upon them. H, state and federal courts, the neutral arbiters responsible for ensuring the fair and even-handed administration of election laws, rejected every outcome determinative post-election lawsuit filed by the defendant, his co-conspirators, and allies, providing the defendant real-time notice that his allegations were meritless. 12. The defendant widely disseminated his false claims of election fraud for months, despite the fact that he knew and in many cases had been informed directly that they were not true. The defendant's knowingly false statements were integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' rights to vote and have their votes counted. He made these knowingly false claims throughout the post-election time period, including those below that he made immediately before the attack on the Capitol on January 6th. Just double checking here. Right. So all of this evidence that's been given to a grand jury, this is has been submitted to a grand jury. All of it has to be sworn. So everyone would be looking at severe perjury charges here in prison time if this information was incorrect. But there are so many people. This is technically evidence. It's the evidence to show probable cause for the indictment, which the grand jury did find in order to go forward on the indictment. So I need to grab another cup of coffee. I will be right back. Okay, here we go. Now, I don't mind political discourse here, but let's be respectful. I would appreciate that. It is very early. I am reading this for the second time, happily doing so, but oh yes, of course, but would very much be appreciative of please being respectful. Listen, true earth, true man, that is not respectful. So let's just take care of that. And just because it's early doesn't mean my moderators aren't here. So it's fine to have your political discourse, no problem, but just reading through this. So I'm not pointing out anything one way or the other. I am just reading through this indictment. So okay, here we go. Let's get back into it. Thank you. Oh, thank you. Thank you for the compliment. Yes, absolutely. So let's dive back in. I'm on my second pot of coffee, so we'll go forward here. A, the defendant insinuated that more than 10,000 dead voters had voted in Georgia. Just 4 days earlier, Georgia's Secretary of State had explained to the defendant that this was false. So this is the Secretary of State explaining this. The defendant asserted that there had been 205,000 more votes than voters in Pennsylvania. The defendant's acting attorney general and acting deputy attorney general had explained to him that this was false. C. The defendant said that there had been a suspicious vote dump in Detroit, Michigan. The defendant's attorney general had explained to the defendant that this was false. So let's just underline here, we've got the attorney general coming in. The defendant's allies in the Michigan state legislature, the Speaker of the House of Representatives and Majority Leader of the Senate had publicly announced that there was no evidence of substantial fraud in the state. D. The defendant claimed that there had been tens of thousands of double votes and other fraud in Nevada. The Nevada Secretary of State, again, each of these people would be called in to testify, had previously rebutted the defendant's fraud claims by publicly posting a facts versus myths document explaining that Nevada judges had reviewed rejected them, and the Nevada Supreme Court had rendered a decision denying such claims. So again, this evidence is coming from the Nevada Supreme Court. The defendant said that more than 30,000 non-citizens had voted in Arizona. The defendant's own campaign manager had explained to him that such claims were false, and the Speaker of the Arizona House of Representatives, again, we have another witness here, who supported the defendant in the election, had issued a public statement that there was no evidence of substantial fraud in Arizona. F. The defendant asserted that voting machines in various contested states had switched votes from defendant to Biden. The defendant's attorney general, acting attorney general, and acting deputy attorney general all had explained to him that this was false, and numerous recounts and audits had confirmed the accuracy of the voting machines. Well, paid men do lie, but I don't think that the Nevada Supreme Court has been paid. At least I would hope not. My goodness. The criminal agreement enacts to affect the objects of conspiracy. The defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. Yes, I'm just reading. I'm just reading the the indictment here. I'm just reading. I'm just the messenger. Shortly after Election Day, which fell on November 3rd of 2020, the defendant launched his criminal scheme. On November 13th, the defendant's campaign attorneys conceded in court that he had lost the vote count in the state of Arizona, meaning based on the assessment the defendant's campaign advisors had given him just a week earlier, the defendant had lost the election. So the next day, the defendant turned to co-conspirator 1, whom he announced would spearhead his efforts going forward to challenge the election results. From that point on, the defendant and his co-conspirators executed a strategy to use knowing deceit in the targeted states to impair, obstruct, and defeat the federal government function, including as described below. And then they break these apart state by state. So we will start with Arizona. On November 13th of 2020, the defendant had a conversation with his campaign manager, who informed him that a claim had been circulating that a substantial number of non-citizens had voted in Arizona was false. On November 22nd, 8 days before Arizona's governor certified the ascertainment of the state's legitimate electors based on the popular vote, the defendant and co-conspirator 1 called the Speaker of Arizona House of Representatives, so we have another witness here, and made knowingly false claims of election fraud aimed at interfering with the ascertainment of and voting by Arizona's electors as follows. The defendant and co-conspirator 1 falsely asserted, among other things, that a substantial number of non-citizens, non-residents, and dead people had voted fraudulently in Arizona. The Arizona House Speaker asked co-conspirator 1 for evidence of the claims, which co-conspirator 1 did not have, but claimed he would provide. Co-conspirator 1 never did so. The defendant and co-conspirator 1 asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud. The Arizona House Speaker refused, stating that doing so would require a 2/3 vote of its members, and he would not allow it without actual evidence of fraud. The defendant and co-conspirator 1 asked the Arizona House Speaker to use the legislature to circumvent the process by which legitimate electors would be ascertained by Biden based on the popular vote, and replace those electors with new slate for the defendant. The Arizona House Speaker refused, responding that the suggestion was beyond anything he had ever heard or thought of as something within his authority. On December 1st, co-conspirator 1 met with the Arizona House Speaker. When the Arizona House Speaker again asked co-conspirator 1 for evidence of the outcome determinative election fraud he and the defendant had been claiming, co-conspirator 1 responded with the words to the effect of, "We don't have the evidence, but we have lots of theories." On December 4th, the Arizona House Speaker issued a public statement that said, in part, thank you for the flowers, appreciate that. No election is perfect, and if there were evidence of illegal votes or improper count, then Arizona law provides a process to contest the election, a lawsuit under state law. But the law does not authorize the legislature to reverse the results of an election. As a conservative Republican, I don't like the results of the presidential election. I voted for President Trump and worked hard to re-elect him, but I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. I and my fellow legislators swore an oath to support the United States Constitution and the Constitution and laws of the state of Arizona. It would violate that oath, the basic principles of Republican government, and the rule of law if we attempted to nullify the the people's vote based on unsupported theories of fraud. Under the laws that we wrote and voted upon, Arizona voters choose who wins, and our system requires that their choice be respected. Number 18, on the morning of January 4th of 2021, co-conspirator 2 called the Arizona House Speaker to urge him to use a majority of the legislature to decertify the state's legitimate electors. Arizona's validly ascertained electors had voted 3 weeks earlier and sent their votes to Congress, which was scheduled to count those votes in Biden's favor in just 2 days' time at January 6th certification proceeding. When the Arizona House Speaker explained that the state investigations had uncovered no evidence of substantial fraud in the state, co-conspirator 2 conceded that he, quote, didn't know enough about the facts on the ground, end quote, in Arizona, but nonetheless told the Arizona House Speaker, again, here's another witness, to decertify and let the courts sort it out. The Arizona House Speaker refused, stating that he would not play with the oath he had taken to uphold the United States Constitution and Arizona laws. On January 6th, the defendant publicly repeated the knowingly false claim that 36,000 non-citizens had voted in Arizona. And again, each of these different things are probable cause that's needed, and that's all that's needed for an indictment. We certainly do not have proof beyond a reasonable doubt. That's what a trial is for. So let's move to Georgia then. Here we go. On the lack of exculpatory evidence doesn't come into play until we have a named defendant. And this indictment is naming the defendant. So now when we go forward, then of course the Brady rule would attach and exculpatory evidence would need to be given to the other side. Yes, I will try to do a better job here with my page turning technique. It is not the best. I'll be the first to admit that. On November 16th of 2020, on the defendant's behalf, his executive assistant sent co-conspirator 3 and others a document containing bullet points critical of a certain voting machine company, writing, see attached. This is a direct quote. See attached. Please include as is or almost as is in lawsuit. Co-conspirator 3 responded 9 minutes later, writing, it must go in all suits in Georgia and Pennsylvania immediately with a fraud claim that requires the entire election to be set aside in those states and machines impounded for nonpartisan professional inspection, end quote. On November 25th, co-conspirator 3 filed a lawsuit against the governor of Georgia, falsely alleging massive election fraud accomplished through the voting machines company's election software and hardware. Before the lawsuit was even filed, the defendant retweeted a post promoting it. The defendant did this despite the fact that when he had discussed co-conspirator 3's far-fetched public claims regarding the voting machine company in private with advisors, the defendant had conceded that they were unsupported and that co-conspirator 3 sounded crazy. Direct quote. Co-conspirator 3's Georgia lawsuit was dismissed on December 7th. On December 3rd, co-conspirator 1 orchestrated a presentation to a judiciary subcommittee of the Georgia State Senate with the intention of misleading state senators into blocking the ascertainment of legitimate electors. During the presentation, an agent of the defendant and co-conspirator 1 falsely claimed that more than 10,000 dead people voted in Georgia. That afternoon, the senior advisor to the defendant told the defendant's chief of staff through text messages, quote, just an FYI, a campaign lawyer and his team verified that the 10K plus supposed dead people voting in Georgia is not accurate. It was alleged in co-conspirator 1's hearing today. The senior advisor clarified that he believed that the actual number was 12. B. Another agent of the defendant and co-conspirator 1 played a misleading excerpt of a video recording of ballot counting in State Farm Arena in Atlanta and insinuated that it showed election workers counting suitcases of illegal ballots. Co-conspirator 2 encouraged the legislatures to decertify the state's legitimate electors based on false allegations of election fraud. Also, on December 3rd, the defendant issued a tweet amplifying the knowingly false claims made at co-conspirator 1's presentation in Georgia. Quote, "Wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Plenty more coming, but this alone leads to an easy win for the state." End quote. Number 22. Again, we're in Georgia right now, for those just joining us. Also on December 3rd, the defendant issued sorry about that, trying to keep track. It's early, people. It's very early. On December 4th, the Georgia Secretary of State's chief operating officer debunked the claims made at co-conspirator 1's presentation the previous day, issuing a tweet stating the 90-second video of election workers at State Farm Arena purporting to show fraud was watched in its entirety hours by these investigators. Shows normal ballot processing. Here is the fact check on it. On December 7th, he reiterated during a press conference that the claim that there had been misconduct at State Farm Arena was false. On December 8th, the defendant called the Georgia Attorney General to pressure him to support an election lawsuit filed in the Supreme Court by another state's attorney general. The Georgia Attorney General told the defendant that officials had investigated various claims of election fraud in the state and were not seeing evidence to support them. Also on December 8th, the senior campaign advisor, who spoke with the defendant on a daily basis and had informed him on multiple occasions that various fraud claims were untrue, expressed frustration that many of co-conspirator 1 and his legal team's claims could not be substantiated. As early as mid-November, for instance, the senior campaign advisor had informed the defendant that his claims of a large number of dead voters in Georgia were untrue. With respect to the persistent false claim regarding State Farm Arena on December 8th, the senior campaign advisor wrote in an email, "When our research and campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 0 to 32. This must be the open lawsuits on our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy, this word, beamed down from the mothership." George Soros? Oh my goodness. I wish I was getting paid for this. Nope, all free. All free just to be of assistance. To offer this information to anyone who needs it. All right, moving on. Here we go. On December 10th, 4 days before Biden's validly ascertained electors were scheduled to cast votes and send them to Congress, co-conspirator 1 appeared at a hearing before the Georgia House of Representatives Government Affairs Committee. Co-conspirator 1 played the State Farm Arena video again and falsely claimed that it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then he cited 2 election workers by name, baselessly accused them of quite obviously surreptitiously passing around USB ports as they are vials of these kinds of illegal items, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. Therefore, the 2 election workers received numerous death threats. On December 15th, the defendant summoned the incoming acting attorney general, the incoming acting deputy attorney general, and others to the Oval Office to discuss allegations of election fraud. During the meeting, the Justice Department officials specifically refuted the defendant's claim about State Farm Arena, explaining to him that the activity shown on the tape co-conspirator 1 had used was benign. On December 23rd, a day after defendant's chief of staff personally observed the signature verification process at the Cobb County Civic Center and notified the defendant that the state election officials were conducting themselves in an exemplary fashion and would find fraud if it existed. The defendant tweeted that the Georgia officials administering the signature verification process were trying to hide evidence of election fraud and were terrible people. In the phone call on December 27th, the defendant spoke with the acting attorney general and acting deputy attorney general. During the call, the defendant again pressed the unfounded claims regarding the State Farm Arena, and the two top Justice Department officials again rebutted the allegations, telling him that the Justice Department had reviewed the videotape and interviewed witnesses and had not identified any suspicious conduct. On December 31st, the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor. In advance of filing, co-conspirator 2, who was advising the defendant on the lawsuit, acknowledged in an email that he and the defendant had, since signing a previous verification, quote, been made aware that some of the allegations and evidence proffered by the experts has been inaccurate, and that signing a new affirmation with that knowledge and incorporation by reference would not be accurate. The defendant and co-conspirator 2 caused the defendant's signed verification to be filed nonetheless. On January 2nd, 4 days before Congress's certification proceeding, the defendant and others called Georgia's Secretary of State. During the call, the defendant lied to the Georgia Secretary of State to induce him to alter Georgia's popular vote count and to call into question the validity of the Biden's electors' votes, which had been transmitted to Congress weeks before, including as follows. The defendant raised allegations regarding the State Farm Arena video and repeatedly disparaged one of the same election workers that co-conspirator 1 had maligned on December 10th, using her name almost 20 times and falsely referring to her as, quote, a professional vote scammer and hustler, end quote. In response, the Georgia Secretary of State refuted this, quote, you're talking about the State Farm video, and I think it's extremely unfortunate that co-conspirator 1 or his people, they sliced and diced that video and took it out of context, end quote. When the Georgia Secretary of State then offered a link to a video that would disprove co-conspirator 1's claim, the defendant responded, I don't care about the link. I don't need it. Georgia Secretary of State, I have a much better link. The defendant asked about rumors that paper ballots cast in the election were being destroyed, and the Georgia Secretary of State's counsel explained to him that the claim had been investigated and was not true. The defendant claimed that 5,000 dead people voted in Georgia, causing the Georgia Secretary of State to respond, well, Mr. President, the challenge that you have is the data you have is wrong. The actual number were two people that were dead that voted. And so your information's wrong. That was 2. The defendants claim that the thousands of out-of-state voters had cast ballots in Georgia's election, which the Georgia Secretary of State's counsel refuted, explaining, we've been going through each of those as well, and those numbers that we got that defendant's counsel was just saying, they're not accurate. Everyone we've been through are people that lived in Georgia, moved to a different state, but then moved back to Georgia legitimately. They moved back in years ago. This was not like something just before the election. In response to multiple other of the defendant's allegations, the Georgia Secretary of State's counsel told the defendant that the Georgia Bureau of Investigation was examining all such claims and finding no merit to them. The defendant said he needed to find 11,780 votes and insinuated that the Georgia Secretary of State and his counsel could be subject to criminal prosecution if they failed to find election fraud as he demanded, stating, quote, and you are going to find that they are, which is totally illegal, It's more illegal for you than it is for them, because you know what they did and you're not reporting it. That's a criminal, that's a criminal offense. And you can't let that happen. That's a big risk to you and to the Georgia Secretary of State's counsel, your lawyer. The next day, on January 3rd, the defendant falsely claimed that the Georgia Secretary of State had not addressed the defendant's allegations, publicly stating that the Georgia Secretary of State was unwilling or unable to answer questions such as the ballots under table scam, ballot destruction, out-of-state voters, dead voters, and more. He has no clue, end quote. On January 6th, the defendant publicly repeated the knowingly false insinuation that more than 10,300 dead people had voted in Georgia. Hearsay is allowable if it is a statement against a party's interest, also known as admission, and that is under Rule 803 of the Federal Rules of Evidence. So here's Michigan. On November 5th of 2020, the defendant claimed that there had been a suspicious dump of votes, purportedly illegitimate ballots, stating, quote, in Detroit, there were hours of unexplained delay in delivering many of the votes for counting. The final batch did not arrive until 4 a.m, and even though the polls closed at 8 o'clock, so they brought it in, and the batches came in, and nobody knew where they came from. On November 20th, 3 days before Michigan's governor signed a certificate of ascertainment notifying the federal government that based on the popular vote, Biden's electors were to represent Michigan's voters, the defendant held a meeting in the Oval Office with the Speaker of the Michigan House of Representatives. And again, I highlight this as a witness, and the Majority Leader of the Michigan Senate. So again, we have a second witness here. In that meeting, defendant raised his false claims, among others, of an illegitimate vote dump in Detroit. In response, the Michigan Senate Majority Leader told the defendant that he had lost Michigan, not because of fraud, but because the defendant had underperformed with certain voter populations in the state. Upon leaving their meeting, the Michigan House Speaker and Michigan Senate Majority Leader issued a statement reiterating this. The Senate and House Oversight Committees are actively engaged in a thorough review of Michigan's elections process, and we have faith in the committee process to provide greater transparency and accountability to our citizens. We have not yet been made aware of any information that would change the outcome of the election in Michigan, and as legislative leaders, we will follow the law and follow the normal process regarding Michigan's electors, just as we have said throughout this election. December 1st, the defendant raised his Michigan vote dump claim with the Attorney General, who responded that what had occurred in Michigan had been the normal vote counting process and that there was no indication of fraud in Detroit. Despite this, the next day, the defendant made a knowingly false statement that in Michigan, quote, at 6:31 in the morning, a vote dump of 149,772 votes came in unexpectedly. We were winning by a lot. That batch was received in horror. Nobody knew anything about it. It's corrupt. Detroit is corrupt. I have a lot of friends in Detroit. They know it, but Detroit is totally corrupt. On December 4th, co-conspirator 1 sent a text message to the Michigan House Speaker, again another witness, reiterating his unsupported claim of election fraud and attempting to get the Michigan House Speaker to assist in reversing the ascertainment of the legitimate Biden electors, stating, quote, looks like Georgia may well hold some factual hearings and change the certification under Article 3, Section 1, Clause 2 of the Constitution. As co-conspirator 2 explained, they don't just have the right to do it, but the obligation. Help me get this done in Michigan. Article 3 is the judicial branch. Section 1 sets out the courts. Clause 2 explains any courts that the legislature may deem necessary. Similarly, on December 7th, despite still having established no fraud in Michigan, the co-conspirator sent a text intended for the Michigan Senate Majority Leader. Wait, pause. I'm bumping back up. Is this Article 2? Okay, Article 2. Sorry, the executive branch, Section 1, Clause 2. I was quoting Article 3. Just taking a moment here. I may need more coffee to get through this, but we'll keep going. Here we go. Either way, this is incorrect. So the majority leader. So I need you to pass a joint resolution from the Michigan legislature that states that the election is in dispute. There's an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th under Michigan law, end quote. On December 14th, the day the electors in the states across the country were required to vote and submit their votes to Congress, the Michigan House Speaker and Michigan Senate Majority Leader announced that, contrary to the defendant's request, they would not decertify the legitimate election results or electors in Michigan. The Michigan Senate Majority Leader's public statement included, quote, "We have not received evidence of fraud on a scale that would change the outcome of the election in Michigan." Just one moment, please. I need to grab my coffee again. Yes, pause for coffee. Yes, thank you. Thanks for understanding. Oh, goodness. Okay, here we go. Back we go again. Oh, yes, I will share the coffee. I wish I could. Oh, goodness. All right, here we go. Thank you all for joining me today. Again, just reading through this grand jury indictment. I'm just reading what has come down from the grand jury. So I did do a live yesterday and was requested to come back in again this morning for those that may have missed it last night. So, and I'm happy to do that. So here we go. The Michigan House Speaker's public statement read, in part, "We have diligently examined these reports of fraud to the best of our ability. I fought hard for President Trump. Nobody wanted him to win more than me. I think he's done an incredible job, but I love our republic too. I can't fathom risking our norms, traditions, and institutions to pass a resolution retroactively changing the electors for Trump, simply because some think that there may have been enough widespread fraud to give him a win. That's unprecedented for good reason. And that's why there is not enough support in the House to cast a new slate of electors. I feel we'll lose our country forever. This truly would bring mutually assured destruction for every future election in regards to the Electoral College. And I can't stand for that. I won't." On January 6th of 2021, the defendant publicly repeated his knowingly false claim regarding an illicit dump of more than 100,000 ballots in Detroit, Pennsylvania. On November 11th of 2020, the defendant publicly maligned a Philadelphia city commissioner for stating on the news that there was no evidence of widespread fraud in Philadelphia. As a result, the Philadelphia city commissioner and his family received death threats. On November 25th, the day after Pennsylvania's governor signed a certificate of ascertainment and thus certified to the federal government that Biden's electors were the legitimate electors for the state, co-conspirator 1 orchestrated an event at a hotel in Gettysburg attended by state legislators. Co-conspirator 1 falsely claimed that Pennsylvania had issued 1.8 million absentee ballots and received 2.5 million in return. In the days thereafter, a campaign staffer wrote internally that co-conspirator 1's allegations were just wrong and that there's no way to defend it. The deputy campaign manager responded, "We have been saying this for a while. It's very frustrating. On December 4th, after 4 Republican leaders of the Pennsylvania legislature issued a public statement that the General Assembly lacked the authority to overturn the popular vote and appoint its own slate of electors, and that doing so would violate the state election code and constitution, the defendant retweeted a post labeling the legislators cowards. On December 31st and January 3rd, the defendant repeatedly raised with the acting Attorney General and acting Deputy Attorney General the allegations that in Pennsylvania there had been 205,000 more votes than voters, each time the Justice Department officials informed the defendant that his claim was false. On January 6th, the defendant publicly repeated his knowingly false claim that there had been 205,000 more votes than voters in Pennsylvania. Wisconsin. On November 29th of 2020, the recount in Wisconsin that the defendant's campaign had petitioned and paid for did not change the election result, and in fact increased the defendant's margin of defeat. On December 14th, the Wisconsin Supreme Court rejected an election challenge by the campaign. One justice wrote, quote, "Nothing in this case casts any legitimate doubt that the people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our great country." On December 21st, as a result of the state Supreme Court's decision, the Wisconsin governor, who had signed the certificate of ascertainment on November 30th, identifying Biden's electors as the state legitimate electors, signed a certificate of final determination in which he recognized that the state Supreme Court had resolved a controversy regarding the appointment of Biden's electors and confirmed that Biden had received the highest number of votes in the state and that his electors were the state's legitimate electors. That same day, in response to the count decision that had prompted the Wisconsin governor to sign the certificate of final determination, the defendant issued a tweet repeating his knowingly false claim of election fraud and demanding that Wisconsin legislature overturn the election results that had led to the ascertainment of Biden's electors as the legitimate electors. On December 27th, the defendant raised with the acting Attorney General and acting Deputy Attorney General a specific fraud claim that there had been more votes than voters in Wisconsin. The acting Deputy Attorney General informed the defendant that the claim was false. On January 6th of 2021, the defendant publicly repeated knowingly false claims that there had been tens of thousands of unlawful votes in Wisconsin. The defendant's use of dishonesty, fraud, deceit, and to organize fraudulent slates of electors and cause them to transmit false certificates to Congress. So we've moved past all of the states. We've gone state by state. Now we will go into the next part of it. Just keeping an eye here. Thank you all for joining me again. Appreciate that. Yes. Okay, here we go. Just pausing for a moment. Just keeping one eye here on the comments. Oh, you're welcome. You're very welcome. All right, here we go. As the defendant's attempt to obstruct the electoral vote through deceit of state officials met with repeated failure, beginning in early December of 2020, he and his co-conspirators developed a new plan to marshal individuals who would have served as defendants' electors had he won the popular vote in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, and caused those individuals to make and send to the Vice President and Congress false certifications that they were legitimate electors. Under the plan, the submission of these fraudulent slates would create a false controversy at the certification proceeding and position the Vice President presiding on the January 6th as President of the Senate to supplant legitimate electors with defendants' fake electors and certify the defendant as president. The plan capitalized on ideas presented in memoranda drafted by co-conspirator 5, an attorney who was assisting the defendant's campaign with legal efforts related to a recount in Wisconsin. The memoranda evolved over time from a legal strategy to preserve the defendant's rights to a corrupt plan to subvert the federal government function by stopping Biden's electors' votes from being counted and certified as follows. All right, so now we're going to get into 3 separate memoranda here. What brand is my pen? I don't know. It's this brand. Whatever brand that is. Oh. All right, I digress. I'm easily distracted. Here we go, back into it. Here's the first memo. The November 18th memorandum, advocated that because of the ongoing recount in Wisconsin, the defendants' electors there should meet and cast votes on December 14th, the date the ECA required appointed electors to vote, to preserve the alternative of the defendant's Wisconsin elector slate in the event the defendant ultimately prevailed in the state. So that's the Wisconsin memo. B, December 6th memorandum, the fraudulent elector memo, marked a sharp departure from co-conspirators 5's Wisconsin memo, advocating that the alternative electors originally conceived of to preserve rights in Wisconsin instead be used in a number of states as fraudulent electors to prevent Biden from receiving the 270 electoral votes necessary to secure the presidency on January 6th. The fraudulent elector memo suggested that the defendants' electors in 6 purportedly contested states, Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin, should meet and mimic as best as possible the actions of the legitimate Biden electors, and that on January 6th, the vice president should open and count the fraudulent votes, setting up a fake controversy that would derail the proper certification of Biden as president-elect. The December 9th memorandum, fraudulent elector instructions, consisted of co-conspirator 5's instructions on how fraudulent electors could mimic legitimate electors in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin. Co-conspirator 5 noted that in some states it would be virtually impossible for the fraudulent electors to successfully take the same steps as the legitimate electors because state law required formal participation in the process by state officials or access to official resources. All right, let's go forward. What's going to happen with the memos? The plan began in early December, and ultimately the conspirators and the defendant's campaign took the Wisconsin memo and expanded it to any state that the defendant claimed was contested, even New Mexico, which the defendant had lost by more than 10% of the popular vote. This expansion was forecast by emails the defendant's chief of staff sent on December 6th. Forwarding the Wisconsin memo to the campaign staff in writing, "We just need to have someone coordinating the electors for states," end quote. On December 6th, the defendant and co-conspirator 2 called the chairwoman of the Republican National Committee to ensure that the plan was in motion. During the call, co-conspirator 2 told the chairwoman that it was important for the Republican National Committee to help the defendant's campaign gather electors in targeted states, and falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor. After the Republican National Committee's chairwoman consulted the campaign and heard that work on gathering electors were underway, she called and reported this information to the defendant, who responded approvingly. On December 7th, co-conspirator 1 received the Wisconsin memo and the fraudulent elector memo. Co-conspirator 1 spoke with co-conspirator 6 regarding attorneys who could assist in the fraudulent elector effort in the targeted states, and he received from co-conspirator 6 an email identifying attorneys in Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin. The next day, on December 8th, co-conspirator 5 called the Arizona attorney on co-conspirator 6's list. In an email after the call, the Arizona attorney recounted his conversation with co-conspirator 5 as follows. I just talked to the gentleman who did that memo, co-conspirator 5. His idea is basically that all of us, Georgia, Wisconsin, Arizona, Pennsylvania, etc., have our electors send in their votes, even though the votes aren't legal under federal law, because they're not signed by the governor, so that members of Congress can fight about whether they should be counted on January 6th. They could potentially argue that they're not bound by federal law because they're Congress and made the law, etc. Kind of wild/creative. I'm happy to discuss. My comment to him was that I guess there's no harm in it, legally at least, i.e. we could just be sending in fake electoral votes to Pence so that someone in Congress can make an objection when they start counting votes and start arguing that the fake votes should be counted. Yeah, this is not good. That's not good. And because it's a direct quote, they must have evidence to support that. At co-conspirator 1's direction, on December 10th, co-conspirator 5 sent to points of contact in all targeted states except Wisconsin, which had already received his memos, and New Mexico, a streamlined version of the Wisconsin memo, which did not reveal the intended fraudulent use of the defendant's electors and the fraudulent elector instructions, along with fraudulent elector certificates that he had drafted. The next day, on December 11th, through co-conspirator 5, co-conspirator 1 suggested that the Arizona lawyer file a petition for certiorari to the Supreme Court as a pretext to claim that litigation was pending in the state to provide cover for the convening and voting of the defendant's fraudulent electors there. Co-conspirator 5 explained that co-conspirator 1 had heard from a state official and state provisional elector that it could appear treasonous for the Arizona electors to vote on Monday if there is no pending court proceeding. End quote. To manage the plan in Pennsylvania on December 12th, co-conspirator 1, co-conspirator 5, and co-conspirator 6 participated in a conference call organized by the defendant's campaign with the defendant's electors in that state. When the defendant's electors expressed concern about signing certificates representing themselves as legitimate electors, co-conspirator 1 falsely assured them that their certificates would be used only if the defendant succeeded in litigation. Subsequently, co-conspirator 6 circulated proposed conditional language to that effect for potential inclusion in fraudulent elector certificates. A campaign official cautioned not to offer the conditional language to other states because, quote, the other states are signing what he prepared. If it gets out, we change the language for Pennsylvania, it could snowball. In some cases, the defendant's electors refused to participate in the plan. Good for them. On December 13th, co-conspirator 5 sent co-conspirator 1 an email memorandum that further confirmed the conspirators' plan that was not to use fraudulent electors only in the circumstance that the defendant's litigation was successful in one of the targeted states. Instead, the plan was to falsely present the fraudulent slates as an alternative to the legitimate slates at Congress's certification proceeding. Right. On December 13th, the defendant asked the senior campaign advisor for an update on what was going on with the elector plan and directed him to put out a statement on electors. As a result, co-conspirator 1 directed the senior campaign advisor to join a conference call with him. Co-conspirator 6 and others, when the senior campaign advisor related these developments in text messages to the deputy campaign manager, a senior advisor to the defendant, and a campaign staffer, the deputy campaign manager responded, quote, here's the thing, the way this has morphed, it's a crazy play, so I don't know who wants to put their name on it, end quote. The senior advisor wrote, certifying illegal votes. In turn, the participants in the group text message, Okay. In turn, the participants in the group text message refused to have a statement regarding electors attributed to their names because none of them could stand by it. Also, on December 13th, at a campaign staffer's request, co-conspirator 5 drafted and sent fraudulent elector certificates for the defendants' electors in New Mexico, which had not previously been among the targeted states and where there was no pending litigation on the defendants' behalf. The next day, the defendants' campaign filed an election challenge suit in New Mexico at 11:54 a.m., 6 minutes before the noon deadline for the electors' votes, as a pretext so that there was pending litigation there at the time the fraudulent electors voted. On December 14th, the legitimate electors of all 50 states and the District of Columbia met in their respective jurisdictions to formally cast their votes for president, resulting in a total of 232 electoral votes for the defendant and 306 for Biden. The legitimate electoral votes that Biden won in the states that the defendant targeted and the defendant's margin of defeat were as follows: Arizona, 11 electoral votes. Georgia, 16 electoral votes. Michigan, 16 electoral votes. Nevada, 6 electoral votes. New Mexico, 5 electoral votes. Pennsylvania, 20 electoral votes. And Wisconsin, 10 electoral votes. On the same day, this is the grand jury indictment. This certainly isn't a script. My goodness, I'm not that talented by any means whatsoever. So this is the grand jury indictment that has come down. Again, probable cause is the only level of proof that is needed for an indictment. Proof beyond a reasonable doubt has to be shown at trial. On the same day, at the direction of the defendant and co-conspirator 1, fraudulent electors convened sham proceedings in the 7 targeted states to cast fraudulent electoral ballots in favor of the defendant. In some states, in order to satisfy legal requirements set forth legitimate electors under state law, state officials were enlisted to provide the fraudulent electors access to the state capitol buildings so that they could gather and vote there. In many cases, however, as co-conspirator 5 had predicted in the fraudulent elector instructions, the fraudulent electors were unable to satisfy the legal requirements. Nonetheless, as directed in the fraudulent elector instructions, shortly after the fraudulent electors met on December 4th, the targeted states' fraudulent elector certificates were mailed to the President of the Senate, the Archivist of the United States, and others. The defendant and co-conspirators ultimately used the certificates of those fraudulent electors to deceitfully target the government function and did so contrary to how fraudulent electors were told they would be used. Unlike those of fraudulent electors, consistent with the ECA, the legitimate electors signed certificates that were annexed to the state's executive's certificates of ascertainment before being sent to the President of the Senate and others. That evening, 6:26 p.m., the Republican National Committee chairwoman forwarded to the defendant, through his executive assistant, an email titled Electors Recap Final, which represented that in 6 contested states, Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin, the defendant's electors had voted in parallel to Biden's electors. The defendant's executive assistant responded, "It's in front of him." The defendant's attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors in electoral votes with the defendants. Okay, we will pause for coffee for just one moment, please, if you will allow me. Okay, thank you for your patience. And here we go. Let's jump right back in to number 70. We are on number 70 here. So, in late December of 2020, the defendant attempted to use the Justice Department to make knowingly false claims of election fraud to officials in the targeted states through a formal letter under the acting attorney general's signature, thus giving the defendant's lies the backing of the federal government and attempting to improperly influence the targeted states to replace legitimate Biden electors with the defendants. On December 22nd, the defendant met with co-conspirator 4 at the White House. Co-conspirator 4 had not informed his leadership at the Justice Department of the meeting, which was a violation of the Justice Department's written policy restricting contacts with the White House to guard against improper political influence. 74. On December 26th, co-conspirator 4 spoke on the phone with the acting attorney general and lied about the circumstances of his meeting with the defendant at the White House, falsely claiming that the meeting had been unplanned. The acting attorney general directed co-conspirator 4 not to have unauthorized contacts with the White House again, and co-conspirator 4 said he would not. Thank you for the heart. Oh my goodness. Oh, we will get through this together. The next morning, on December 27th, contrary to the acting attorney general's direction, co-conspirator 4 spoke with the defendant on the defendant's cell phone for nearly 3 minutes. That afternoon, the defendant called the acting attorney general and acting deputy attorney general and said, among other things, quote, "People tell me co-conspirator 4 is great. I should put him in," end quote. The defendant also raised multiple false claims of election fraud, which the acting attorney general and acting deputy attorney general refuted. When the acting attorney general told the defendant that the Justice Department could not and would not change the outcome of the election, the defendant responded, "Just say that the election was corrupt and leave the rest to me and the Republican congressman." Right, so taking a moment to pause in that. Okay, on December 28th, co-conspirator 4 sent a draft letter to the acting attorney general and acting deputy attorney general. Oh my goodness, thank you. Which he proposed they all sign. The draft was addressed to the state officials in Georgia, and co-conspirator 4 proposed sending versions of the letter to elected officials in other targeted states. The proposed letter contained numerous knowingly false claims about the election and the Justice Department, including that A, the Justice Department had identified significant concerns that may have impacted the outcome of the election in multiple states. B, the Justice Department believed that in Georgia and other states, 2 valid slates of electors had gathered at the proper location on December 14th, and that both sets of ballots had been transmitted to Congress. That is, co-conspirator 4's letter sought to advance the defendant's fraudulent elector plan by using the authority of the Justice Department to falsely present the fraudulent electors as a valid alternative to the legitimate electors. The Justice Department urged that the state legislature convene a special legislative session to create the opportunity to, among other things, choose the fraudulent electors over the legitimate electors. It, of course, is extremely disheartening to see the behavior of these attorneys. It's extremely disheartening. The acting deputy attorney general promptly responded to co-conspirator 4 by email and told him that his proposed letter was false, writing, quote, "Despite the dramatic claims to the contrary, we have not seen the type of fraud that calls into question the reported and certified results of the election," end quote. In a meeting shortly thereafter, the acting attorney general and acting deputy attorney general again directed co-conspirator 4 not to have unauthorized contact with the White House. On December 31st, the defendant summoned to the Oval Office the acting attorney general, acting deputy attorney general, and other advisors, In the meeting, the defendant again raised the claims about election fraud that the Justice Department officials had already told him were not true, and that the senior Justice Department officials reiterated were false, and suggested he might change the leadership of the Justice Department. On December 2nd of 2021, just 4 days before Congress's certification proceedings, co-conspirator 4 tried to coerce the acting Attorney General and acting Deputy Attorney General to sign and send co-conspirator 4's draft letter, which contained false statements to state officials. He told them that the defendant was considering making co-conspirator 4 the new acting Attorney General. But that co-conspirator 4 would decline the defendant's offer if the acting Attorney General and acting Deputy Attorney General would agree to send the proposed letter to the targeted states. The Justice Department officials refused. The next morning, on January 3rd, thank you for that moment of brevity. Despite having uncovered no additional evidence of election fraud, co-conspirator 4 sent to a Justice Department colleague an edited version of his draft letter to the states, which included a change from its previous claim that the Justice Department had concerns to a stronger false claim that, quote, as of today, there is evidence of significant irregularities that may have impacted the outcome of the election in multiple states. Also, on the morning of January 3rd, co-conspirator 4 met with the defendant at the White House, again without having informed senior Justice Department officials, and accepted the defendant's offer that he become acting Attorney General. No, I'm not being held captive, other than my extreme disappointment in the actions of a licensed attorney. On the afternoon of January 3rd, co-conspirator 4 spoke with a deputy White House counsel. The previous month, the deputy White House counsel had informed the defendant that there is no world, there is no option in which you do not leave the White House on January 20th. Now, the same deputy White House counsel tried to dissuade co-conspirator 4 from assuming the role of acting Attorney General. The deputy White House counsel reiterated to co-conspirator 4 that there had not been outcome determinative fraud in the election, and that if the defendant remained in office nonetheless, there would be riots in every major street in the United States. Co-conspirator 4 responded, well, deputy White House counsel, that's why there's an Insurrection Act. Also that afternoon, co-conspirator 4 met with the acting Attorney General and told him that the defendant had decided to put co-conspirator 4 in charge of the Justice Department. The acting Attorney General responded that he would not accept being fired by a subordinate and immediately scheduled a meeting with the defendant for that evening. On the evening of January 3rd, the defendant met for a briefing on an overseas national security issue with the chairman of the Joint Chiefs of Staff and other senior national security advisors. The chairman briefed the defendant on the issue, which had previously arisen in December, as well as possible ways the defendant could handle it. When the chairman and another advisor recommended that the defendant take no action because inauguration day was only 17 days away, and any course of action could trigger something unhelpful, the defendant calmly agreed, stating, quote, yeah, you're right, it's too late for us, we're going to give that to the next guy. The defendant moved immediately from this national security briefing to the meeting that the acting Attorney General had requested earlier that day, which included co-conspirator 4, the acting Attorney General, the acting Deputy Attorney General, and the Justice Department's Assistant Attorney General for the Office of Legal Counsel, the White House Counsel, the Deputy White House Counsel, and Senior Advisor. At the meeting, the defendant expressed frustration with the acting attorney general for failing to do anything to overturn the election results. And the group discussed co-conspirator 4's plan to investigate purported election fraud and to send his proposed letter to state officials, a copy of which was provided to the defendant during the meeting. The defendant relented in his plan to replace the acting attorney general with co-conspirator 4 only when he was told that it would result in mass resignations at the Justice Department and of his own White House counsel. At the meeting in the Oval Office on the night of January 3rd, co-conspirator 4 suggested that the Justice Department should opine that the Vice President could exceed his lawful authority during the certification proceeding and change the election outcome. When the Assistant Attorney General for the Office of Legal Counsel began to explain why the Justice Department should not do so, the defendant said, quote, "No one here should be talking to the Vice President. I'm talking to the Vice President," end quote, and ended the discussion. The defendant's attempt to enlist the Vice President to fraudulently alter the election results at the January 6th certification proceeding. As January 6th congressional certification proceeding approached and other efforts to impair, obstruct, and defeat the federal government function failed, the defendant sought to enlist the Vice President to use his ceremonial role as at the certification to fraudulently alter the election results. The defendant did this first by using knowingly false claims and election fraud to convince the Vice President to accept the defendant's fraudulent electors, reject legitimate electoral votes, or send legitimate electoral votes to state legislatures for review rather than count them. When that failed, the defendant attempted to use a crowd of supporters that he had gathered in Washington, D.C. to pressure the Vice President to fraudulently alter the election results. On December 19th, after cultivating widespread anger and resentment for weeks with his knowingly false claims of election fraud, the defendant urged his supporters to travel to Washington on the day of the certification proceeding, tweeting, quote, "Big protest in D.C. on January 6th. Be there, will be wild," end quote. Throughout late December, he repeatedly urged his supporters to come to Washington for January 6th. On December 23rd, the defendant retweeted a memo titled Operation Pence Card, which falsely asserted that Vice President Pence could, among other things, unilaterally disqualify legitimate electors from 6 targeted states. On the same day, co-conspirator 2 circulated a 2-page memorandum outlining a plan for the Vice President to unlawfully declare the defendant the certified winner of the presidential election. In the memorandum, co-conspirator 2 claimed that 7 states had transmitted 2 slates of electors and proposed that the Vice President announce that, quote, "Because of the ongoing disputes in the 7 states, there are no electors that can be deemed validly appointed in those states," end quote. Next, co-conspirator 2 proposed steps that he acknowledged violated the ECA. Advocating, in the end, quote, "Pence then gavels President Trump as reelected," end quote. Just 2 months earlier, on October 11th, co-conspirator 2 had taken the opposite position, writing that neither the Constitution nor the ECA provided the Vice President discretion in counting of electoral votes or permitted him to make the determination on his own. On several private phone calls in the late December and early January, the defendant repeated knowingly false claims of election fraud and directly pressured the Vice President to use his ceremonial role at the certification proceeding on January 6th to fraudulently overturn the results of the election, and the Vice President resisted, including on December 25th, when the Vice President called the defendant to wish him a Merry Christmas. The defendant quickly turned the conversation to January 6th and his request that the Vice President reject electoral votes that day. The Vice President pushed back, telling the defendant, as the Vice President already had in previous conversations, quote, I don't think I have the authority to change the outcome, end quote. On December 29th, as reflected in the vice president's contemporaneous notes, good job with the note-taking, the defendant falsely told the vice president that the Justice Department was finding major infractions. On January 1st, the defendant called the vice president and berated him because he had learned that the vice president had opposed a lawsuit seeking a judicial decision that at the certification, the vice president had the authority to reject or return votes to the states under the Constitution. The vice president responded that he thought there was no constitutional basis for such authority and that it was improper. In response, the defendant told the vice president, quote, "You're too honest," end quote. Within hours of the conversation, the defendant reminded his supporters to meet in Washington before the certification proceeding, tweeting, quote, the big protest rally in Washington, D.C. will take place at 11 a.m. on January 6th. Locational details to follow. Stop the steal, end quote. On January 3rd, the defendant again told the vice president that at the certification proceeding, the vice president had the absolute right to reject electoral votes and the ability to overturn the election. The vice president responded that he had no such authority and that a federal appeals court had rejected the lawsuit making the claim the previous day. On January 3rd, co-conspirator 2 circulated a second memorandum that included a new plan under which, contrary to the ECA, the vice president would send the elector slates to the state legislatures to determine which slate to count. On January 4th, the defendant held a meeting with co-conspirator 2, the vice president and vice president's chief of staff, and the vice president's counsel for the purpose of convincing the vice president, based on the defendant's knowingly false claims of election fraud, that the vice president should reject or send to the states Biden's legitimate electoral votes rather than count them. The defendant deliberately excluded his White House counsel from the meeting because the White House counsel previously had pushed back on the defendant's false claims of election fraud. During the meeting, as reflected in Vice President's contemporaneous notes, the defendant made knowingly false claims of election fraud, including, bottom line, we won every state by hundred thousands of votes, and we won every state, and asked regarding a claim his senior Justice Department officials previously had told him was false, including as recently as the night before, what about 205,000 votes more in Pennsylvania than voters? The defendant and co-conspirator 2 then asked the vice president to either unilaterally reject the legitimate electors from the 7 targeted states or send the question of which slate was legitimate to the targeted states' legislatures. When the vice president challenged co-conspirator 2 on whether the proposal to return the question to the states was defensible, co-conspirator 2 responded, quote, well, nobody's tested it before, end quote. The vice president then told the defendant, quote, did you hear that? Even your own counsel is not saying I have that authority, end quote. The defendant responded, that's okay. I prefer the other suggestion of the vice president rejecting the electorals unilaterally. And that takes us over to the next page, number 94. I am noting my battery is low, so if you'll just give me about a minute, I will get charged up here. I will be right back, so just one moment, please. Okay. And here we go. Thank you for your patience. Is this back in frame okay? Can everyone see? Take a minute. Yes. Oh, my goodness. Okay, you are welcome. You're welcome. Are we in frame? Okay, great. I will dive right back in here. Let me just readjust here. As we go forward. And I'm really not anyone special here. I'm just a lawyer and a teacher, so just sharing what's going on. All right. Whew. Here we go. Also, on January 4th, when the co-conspirator 2 acknowledged to the defendant's senior advisor that no court would support his proposal, the senior advisor told co-conspirator 2, quote, "You're going to cause riots in the streets." Co-conspirator 2 responded that there had previously been points in the nation's history where violence was necessary to protect the republic. After that conversation, the senior advisor noted the defendant that co-conspirator 2 had conceded that his plan was not going to work. On the morning of January 5th, at the defendant's direction, the vice president's chief of staff and the vice president's counsel met again with co-conspirator 2. Co-conspirator 2 now advocated that the vice president do what the defendant had said he preferred the day before, unilaterally reject electors from the targeted states. During this meeting, co-conspirator 2 privately acknowledged to the vice president's counsel that he hoped to prevent judicial review of his proposal because he understood that it would be unanimously rejected by the Supreme Court. The vice president's counsel expressed to co-conspirator 2 that following through with the proposal would result in a disastrous situation where the election might have to be decided in the streets. The same day, the defendant encouraged supporters to travel to Washington on January 6th, and he set the false expectation that the vice president had the authority to and might use his ceremonial role as the certification process to reverse the election outcome in the defendant's favor, including issuing the following tweets. At 11:06 a.m., the vice president has the power to reject fraudulently chosen electors. This was within 40 minutes of the defendant's earlier reminder, "See you in D.C." At 5:05 p.m., Washington is being inundated with people who don't want to see an election victory stolen. Our country has had enough. They won't take it anymore. We hear you and love you from the Oval Office. At 5:43 p.m., I will be speaking at the Save America rally tomorrow on the ellipse from 11 a.m. Eastern. Arrive early, doors open at 7 a.m. Eastern. Big crowds. Also on January 5th, the defendant met alone with the vice president. When the vice president refused to agree to the defendant's request that he obstruct the certification, the defendant grew frustrated and told the vice president that the defendant would have to publicly criticize him. Upon learning this, the vice president's chief of staff was concerned for the vice president's safety and alerted the head of the vice president's Secret Service detail. As crowds begin to gather in Washington, and were audible from the Oval Office, the defendant remarked to advisors that the crowd the following day on January 6th was going to be angry. That night, the defendant approved and caused the defendant's campaign to issue a public statement that the defendant knew from his meeting with the vice president only hours earlier was false. The vice president and I are in total agreement that the vice president has the power to act. On January 6th, starting early in the morning hours, the defendant again turned to knowingly false statements aimed at pressuring the vice president to fraudulently alter the election outcome, and raised publicly the false expectations that the vice president might do so. At 1 a.m., the defendant issued a tweet that falsely claimed, "If Vice President Mike Pence comes through for us, we will win the presidency." Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. At 8:17 a.m., the defendant issued a tweet that falsely stated, "States want to correct their votes, which they now know were based on irregularities and fraud, plus corrupt process never received legislative approval. All Mike Pence has to do is send them back to the states, and we win. Do it, Mike. This is a time for extreme courage." On the morning of January 6th, an agent for the defendant contacted a United States senator to ask him to hand-deliver documents to the vice president. The agent then facilitated the receipt by the senator's staff of the fraudulent certificates, signed by the defendant's fraudulent electors in Michigan and Wisconsin, which were believed not to have been delivered to the vice president or archivist by mail. When one of the senator's staffers contacted a staffer for the vice president by text message to arrange for delivery of what the senator's staffer had been told were alternative slates of electors for Michigan and Wisconsin, because archivists didn't receive them, the vice president's staffer rejected them. At 11:15 a.m., the defendant called the vice president and again pressured him to fraudulently reject or return Biden's legitimate electoral votes. The vice president again refused. Immediately after the call, the defendant decided to single out the vice president in public remarks he would make within the hour, reinserting language that he had personally drafted earlier that morning, falsely claiming that the vice president had authority to send electoral votes to the states, but that advisors had previously successfully advocated be removed. Earlier that morning, the defendant had selected co-conspirator 2 to join co-conspirator 1 in giving public remarks before his own. When they did so, based on knowingly false election fraud claims, co-conspirator 1 and co-conspirator 2 intensified pressure on the vice president to fraudulently obstruct the certification proceeding. Co-conspirator 1 told the crowd that the vice president could cast the ECA aside and unilaterally decide on the validity of these crooked ballots. He also lied when he claimed to have letters from 5 legislatures begging us to send elector slates to the legislatures for review, and called for trial by combat. Co-conspirator 2 told the crowd, "All we are demanding of Vice President Pence is this afternoon at 1 o'clock, he let the legislatures of the state look into this so we can get to the bottom of it, and the American people know whether we have control of the direction of our government or not." We no longer live in a self-governing republic if we can't get the answer to this question. Next, beginning at 11:56 a.m., the defendant made multiple knowingly false statements integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' right to vote and have their votes counted. The defendant repeated false claims of election fraud, gave false hope that the vice president might change the election outcome, and directed the crowd in front of him to go to the Capitol as a means to obstruct the certification and pressure the vice president to fraudulently obstruct the certification. The defendant's knowingly false statements for these purposes included: the defendant falsely claimed that, based on fraud, the vice president could alter the outcome of the election results, stating, "I hope Mike is going to do the right thing. I hope so. I hope so. Because if Mike Pence does the right thing, we can win the election. All he has to do, this is from the number one, or certainly one of the top constitutional lawyers in our country. He has the absolute right to do it. We're supposed to protect our country, support our Constitution, and protect our Constitution. States want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back. All Vice President Pence has to do is send it back to the states to recertify, and we become president, and you are the happiest people." After the defendant falsely stated that the Pennsylvania legislature wanted to recertify their votes, they went on to recertify. They want to recertify, but the only way that can happen is if Mike Pence agrees to send it back. The crowd began to chant, "Send it back." The defendant also said that regular rules no longer applied, stating, quote, "And fraud breaks up everything, doesn't it? When you catch somebody in a fraud, you're allowed to go by very different rules." I'm just going to pause here as an attorney and say that that is incorrect. You still have to follow the rules. Back into it. Finally, after exhorting that we fight like hell, and if you don't fight like hell, you're not going to have a country anymore, the defendant directed the people in front of him to head to the Capitol, suggested he was going with them, and told them to give members of Congress, quote, "the kind of pride and boldness that they need to take back our country." During and after the defendant's remarks, thousands of people marched towards the Capitol. The defendant's exploitation of the violence and chaos at the Capitol. Shortly before 1 p.m., the Vice President issued a public statement explaining that his role as President of the Senate at the certification proceeding that was about to begin did not include unilateral authority to determine which electoral votes should be counted and which should not. Before the defendant had finished speaking, a crowd began to gather at the Capitol. Thereafter, a mass of people, including individuals who traveled to Washington and to the Capitol at the defendant's direction, broke through barriers cordoning off the Capitol grounds and advanced on the building, including by violently attacking law enforcement officers trying to secure it. The defendant, who had returned to the White House after concluding his remarks, watched events at the Capitol unfold on the television in the dining room next to the Oval Office. At 2:13 p.m., after more than an hour of steady violent advancement, the crowd at the Capitol broke into the building. Upon receiving news that the individuals had breached the Capitol, the defendant's advisors told him that there was a riot there and that the rioters had breached the building. When advisors urged defendant to issue a calming message aimed at the rioters, the defendant refused, instead repeatedly remarking that the people at the Capitol were angry because the election had been stolen. At 2:24 p.m., after advisors had left the defendant alone in his dining room, the defendant issued a tweet intended to further delay and obstruct the certification. Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not to the fraudulent or inaccurate ones which they asked to previously certify. USA demands the truth. 1 minute later, the United States Secret Service was forced to evacuate the vice president to a secure location. At the Capitol throughout the afternoon, members of the crowd chanted this upsetting phrase, "Where's Mike Pence? Bring him out," and "Traitor Pence." The defendant repeatedly refused to approve a message directing rioters to leave the Capitol as urged by his most senior advisors, including the White House counsel, a deputy White House counsel, the chief of staff, a deputy chief of staff, and a senior advisor. Instead, the defendant issued 2 tweets, that did not ask rioters to leave the Capitol, but instead falsely suggested that the crowd at the Capitol was being peaceful, including at 2:38 p.m., please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful. And at 3:13 p.m., I'm asking for everyone at the U.S. Capitol to remain peaceful. No violence. Remember, we are the party of law and order. Respect the law and our great men and women in blue. Thank you. At 3 p.m., the defendant had a phone call with the minority leader of the United States House of Representatives. The defendant told the minority leader that the crowd at the Capitol was more upset about the election than the minority leader was. At 4:17 p.m., the defendant released a video message on Twitter that he had just taped in the White House Rose Garden. In it, the defendant repeated the knowingly false claim that, quote, we had an election that was stolen from us, end quote, and finally asked the individuals to leave the Capitol while telling them that they were very special and that we love you. At 4:17 p.m., tweet, as the defendant joined others in the outer Oval Office to watch the attack on the Capitol on television, the defendant said, quote, see, this is what happens when they try to steal an election. These people are angry. These people are really angry about it. This is what happens, end quote. At 6:01 p.m., the defendant tweeted, these are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from the great patriots who have been badly and unfairly treated for so long. Go home with love and in peace. Remember this day forever. On the evening of January 6th, the defendant and co-conspirator 1 attempted to exploit the violence and chaos at the Capitol by calling lawmakers to convince them, based on knowingly false claims of election fraud, to delay the certification, including the defendant, through the White House aides, attempted to reach 2 United States senators at 6 p.m. So you have 2 U.S. senators here. From 6:59 p.m. until 7:18 p.m., co-conspirator 1 placed calls to 5 United States senators and 1 U.S. representative. So we've got another 5 senators and a representative. Co-conspirator 6 attempted to confirm phone numbers for 6 United States senators, whom the defendant had directed co-conspirator 1 to call, and attempt to enlist them in further delaying certification. So here's 6 attempts. In one of the calls, co-conspirator 1 left a voicemail intended for a United States senator that said, we need you, our Republican friends, to try to just slow it down so we can get these legislatures to get more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so that we get ourselves into tomorrow, ideally until the end of tomorrow. So we have another senator. So I'm not sure if these are all different senators. That would be 11, 12, 13, 14 different senators contacted, but I don't know if they're different or not. Including that the vote counts certified by the states to Congress were incorrect. So we have another senator here. And that the governors who certified knew they were incorrect, that illegal immigrants had voted in substantial numbers in Arizona, and that Georgia gave you a number in which 65,000 people who were underage voted. Co-conspirator 1 also claimed that the vice president's action had been surprising and asked the senator to object to every state, any kind of spread this out a little bit like a filibuster. Let me reread that. Co-conspirator 1 also claimed that the vice president's actions had been surprising and asked the senator to, quote, object to every state and kind of spread this out a little bit like a filibuster. At 7:01 p.m., while co-conspirator 1 was calling United States senators on behalf of the defendant, again, these senators are not listed. Who these senators are. I think we are at 15 senators at this point. Does that sound right? Maybe 16? The White House counsel called the defendant to ask him to withdraw any objections and allow certification. The defendant refused. The attack on the Capitol obstructed and delayed the certification for approximately 6 hours until the Senate and House of Representatives came back into session separately at 8:06 p.m. and 9:02 p.m., respectively, and came together in a joint session at 11:35 p.m. At 11:44 p.m., co-conspirator 2 emailed the Vice President's counsel advocating that the Vice President violate the law and seek further delay of the certification. Co-conspirator 2 wrote, quote, "I implore you to consider one more relatively minor violation of the ECA and adjourn for 10 days to allow the legislatures to finish their investigations, as well as to allow a full forensic audit of the massive amounts of illegal activity that has occurred here." At 3:41 a.m., January 7th, as President of the Senate, the Vice President announced the certified results for the 2020 presidential election in favor of Biden. The defendant and his co-conspirators committed one or more of the acts to affect the object of the conspiracy alleged above in paragraphs listed here, in violation of Title 18 United States Code Section 371. And so that takes us to count 2. Count 2, conspiracy to obstruct an official proceeding under violation of 18 U.S. Code, Section 1512, sub K. The allegations contained in paragraphs 1 through 4 and 8 through 123 of this indictment are realleged and fully incorporated here by reference. From on or about November 14th of 2020 through on or about January 7th of 2021 in the District of Columbia and elsewhere, the defendant, Donald J. Trump, did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to corruptly obstruct and impede an official proceeding, that is, the certification of the electoral votes, in violation of Title 18 United States Code 1512, sub C, sub 2. Count 3, obstruction of an attempt to obstruct an official proceeding. And we'll come down here again from on or about November 14th through January 7th in the District of Columbia and elsewhere. The defendant, Donald J. Trump, attempted to and did corruptly obstruct and impede an official proceeding, that is, the certification of the electoral vote, in violation of Code Section 15C2. Count 4, conspiracy against rights. The allegations contained in paragraphs 1 through 4 and 8 through 123 of this indictment are realleged, fully incorporated here by reference. From on or about November 14th of 2020 through on or about January 20th of 2021 in the District of Columbia and elsewhere, the defendant, Donald J. Trump, did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to injure, oppress, threaten, and intimidate one or more person in the free exercise and enjoyment of a right and privilege secured to them by the Constitution and the laws of the United States, that is, the right to vote and to have one's vote counted, in violation of Title 18 United States Code Section 241. So that is the end of the grand jury indictment, which is a lot. It's a lot. Yeah, it's a lot. So it's a pretty big indictment we have here. Again, with our 4 counts, going through all of our different violations that have been alleged. Again, the grand jury only needs probable cause in order to indict. We need proof beyond a reasonable doubt in order to convict. Here, I don't, oh my goodness. This is my second reading of this indictment. I did go live last night to read once and did want to do a morning reading for anyone who was interested in that. So you can find this online, this indictment here, and it is available. It is a public indictment, again, of a grand jury. So these are jurors that decided probable cause based off of the evidence and decided to go forward with these counts. So yes, you're very welcome. You are very welcome. Yes, absolutely. I do have last night's live now posted up on my YouTube channel, which is under my same name. And if you're interested in, going through it again and understanding, it's from last night's live, but it's pretty much the same thing as I've done here. So just recording. So yes, it's just the same as my TikTok name here. And so you can go and check it. And of course, nothing here is monetized in any way. I am just a lawyer. I am just explaining the law here. That's all I do on TikTok is I just explain how the legal system works and just try to educate. So I'm just here for informative purposes. What's my thoughts? I am absolutely not political whatsoever in public. I have my own private thoughts, but, I would say just as an American, extremely patriotic American, my whole family is military, has served for a very long time in the military. It is distressing that there is probable cause. No, there's not a finding of guilt, but there is probable cause, and that's why we have counts. So I certainly can't tell anyone who to vote for. That's just absolutely not my role, or I don't have any kind of power or authority to do that. But just the fact that we've got probable cause on charges of this caliber, I think every single American will really need to decide for themselves what they feel is the right thing to do. And, I can't make that choice for anyone, but if you look historically at any of the charges that anyone has had for public office, for any position, all the way back to, even before a Constitution was written, with John Hancock getting into trouble and John Adams being the attorney in a lot of different situations, I have never seen charges of this caliber regarding this, even regarding the Civil War, when we had questions about the Confederacy breaking off. There were not, at this level, there was no question about electoral votes. There was no question about halting any counting. None of that was involved. And that was, we had a civil war and they still didn't do that. So it's something I think every individual will have to take a look at and try to figure out what they think is right and what's best for the country. I certainly can't make that decision for you, but it is, even as impartial as I am, it is very distressing to hear of these things. And again, if it's not proven beyond a reasonable doubt, that's fine. Then there's no sentence, there's no convictions. That's fine. But we do have probable cause. And I guess I respect the legal system enough when it comes to probable cause to acknowledge that, maybe we don't have convictions here, but there's something. And I'm not sure if just that little something is enough to cause people to think about it for a minute or not. That'll be up to every American. So for me, I personally, and in my family, this is a historical moment for us. So he is indicted. That's what this is. So this is the indictment. Conviction, that's another question. But just to have an indictment is speaks a lot. And, everybody can kind of argue back and forth on the classified documents issue, although legally it's pretty clear cut. There's, documents labeled, you do what you have to do for those labels and you didn't, so we go forward. But when we're talking about an actual sets of fraudulent electors, that's just astronomical. The idea of this kind of sets of people that were gathered to come forward to present false electoral votes is just, it's mind-boggling. It really is. And, again, this is not a finding of guilt, but, and a little bit of background for me, my family's very military. Of course, I am an attorney. I graduated with a degree in political science and rhetoric, and I have been involved in campaigns since I was 6 years old, and for who, I won't say. But, and, I am married, and we were married on the 4th of July. We had a red, white, and blue wedding. And this is disheartening. It's absolutely disheartening. And again, without even a conviction here, we certainly don't have a conviction, but we do have probable cause here. So I think there is some questions that I think everybody needs to ask. And I, of course, can't tell anyone what to do. That's up to each individual, which is how this country is supposed to work. We're supposed to go through this process. So if there are problems, then we need to sort those out. But, those are my thoughts after having a difficult sleeping night and reading this indictment multiple times. Well, Henry, you don't have to stay. If you're not interested, you can scroll on by. That won't bother me whatsoever. And I can understand, Henry, that you would be frustrated and upset with the situation. I know I am as well. But again, you have lots of alternative means of skipping on by for those who want to, who are not interested. So for those that are, that's fine. But yes, and I think at this point, all of us can acknowledge that when people get frustrated and upset with a situation, they tend to go for the cheap shots. And that happens a lot. And let me assure you, after about your fifth homicide situation, those cheap shots really don't matter much anymore. So that's kind of where I'm at. Yeah, I can't take offense at this point. So no worries on that count, but yes, and anyone can ask questions as they go on, and any of the posts that I've done, you can make sure to ask any questions. Yeah, don't hit the door, hit you. Oh, yes. One thing that a lot of people have figured out is that I do chuckle. I do laugh. I have to. I think after you spend as long as I have in criminal justice, you have to. If you don't, you will become just a shadow of who you wish you were. So, thanks for the compliment on the rings. Thank you very much. Why have you not included pictures? I don't have that. I am really just speaking within the four corners of this document. This is all I have. This is all I am going through. So any additional information, there's lots of other places that can be found. But when it comes to just going through this indictment, I'm just telling you the law. So they probably could use that. They probably could use pictures. Oh. Yes, District of Columbia. And again, that's the location of where the offenses allegedly took place. So that's jurisdiction requirements. So, the nail color. Thank you. Appreciate that. It's kind of a quick situation. So the judge might fall asleep, although I doubt it. She seems like she will be kind of on point with what's going on. You should explain probable cause. Oh, absolutely. So probable cause, we've got a couple of different standards of proof. Reasonable suspicion is all that's needed for a stop and frisk. That's under the Terry v. Ohio case. With stop and frisk, you just need to believe that there is criminal activity afoot, and you can go forward as law enforcement when it comes to quick pat downs for weapons. The next is probable cause, and that means you've got probable cause to believe a particular defendant committed a particular offense. That's based on the totality of the circumstances. That level of probable cause is also what's needed for an indictment. So we need to have the totality looked at. Our grand jury will determine if we believe that this particular defendant committed these particular offenses, and they'll go forward and indict. Now, guilt beyond a reasonable doubt is that 98% sure essentially, in a criminal trial, innocent until proven guilty and proven guilty beyond a reasonable doubt. That level of proof is the highest level that we have in our judicial system. To give an example, in our civil system, we have upon a preponderance of the evidence standard, which means one person is 51% responsible for the liability. So that's the preponderance of the evidence. Clear and convincing is another standard that we use. We use that more in administrative situations or quasi-criminal. That's slightly more than a preponderance of the evidence, but below beyond a reasonable doubt. So those are our different standards that we use of our burdens of proof, and then our reasonable suspicion versus probable cause versus beyond a reasonable doubt. So that's kind of just an overview. You can kind of take a look at that, but there is, again, a lot of, again, we're just at a probable cause level when it comes to our different levels of proof at this point. Why is he not in jail currently? We're kind of in uncharted waters at this level. These are rarely used sections of the federal code, honestly, in this kind of a way. And conspiracy against the right to vote, that's never been, to my knowledge, that's never been charged. And please correct me if I'm wrong. I may do some research on that myself. So I think we are just in an uncharted way of being right now. We're trying to kind of figure it out as we go. So we will see what happens with that. But I think that's a good question. I think federal indictments at this level, again, he has not come in for his arraignment. We will see what happens at the arraignment as well. I'm sure there will be a pleading of not guilty. And at that point, we will have bail, bond, those kinds of things all taken into consideration. So, yes, tomorrow. Yes, this is quite a bit more significant than any charges that President Nixon would have been facing, or President Clinton for that matter. So, or both of them combined. So this is just absolutely unprecedented because of the scope here of the charges regarding our democratic process, or constitutional republic process, however you would choose to call that. So user's choice, whatever you call our style of government, this really is some constitutional question. True. I really do. I think you're right with that. I think that's a good point. Yeah, these are just, this is just the grand jury indictment. This isn't, one party or another here. This isn't, I'm certainly not a media channel. I am just a licensed attorney. I'm just here talking through the law with people. I've got no positions one way or the other politically. That is not my role here whatsoever. So that's all I'm here for. The country is a corporation. Well, all right, if you say so, but that's not what we've learned in law school. So is it a strong case? It seems strong to me, and that I am opining. That's my personal view as a former prosecutor and as defense counsel. There's a lot in here. There's a lot of extremely detailed information. There are direct quotes from tweets, letters, memorandums, phone calls. We have exact evidence on all of those things. So that's a lot of evidence. And again, it's a lot that's showing probable cause. Is it beyond a reasonable doubt? That's not, at this point, we can't really make that assessment. I can't make that assessment. So that's kind of where I'm at on that. Well, yeah, I mean, if you want to pick a party, go for it and blame a party. But we're talking here about the Constitution and criminal charges. So I don't know. The only thing involved here has been the Republican National Committee chairwoman was mentioned in here, but other than that, I don't know anything about that. So that's really not my world. I'm sure there's plenty of different channels and people you can go to and hear which side they're on, but that's not really where I go. So I just try to stay out of it. I'm just here for the law. I'm just here to explain things. Would you bring this case if you didn't have substantial proof? No, I would not. I most certainly would not. I most certainly would absolutely not. A case of this magnitude, oh my gosh, no. But again, that level of proof for an indictment versus beyond a reasonable doubt are two different standards. So those are two different things. How will the jury be selected? Great question. I have no idea. At this point. I have no idea what this kind of trial schedule would look like or how they would go about pulling in jurors. It will be absolutely the biggest criminal trial, I think, in the history of our country, quite frankly, which is one of the reasons why I'm here. So just trying to kind of get things explained. Well, we have to have faith in our jury system. We have to. We absolutely worry about biased jurors every time we pull a jury, every single time. That is our number one concern. And we can have significant problems putting a case on in front of biased juries. So we have to trust the process of voir dire and the jury questionnaires and going through and that's how our system works. We rely on our juries. So we just have to kind of go forward and do the best that we can, again, in this situation. So we will see what can happen. It will be incredibly difficult. And he may be innocent. We haven't been, that has not been proven. Is this indictment worse than the previous indictment? Well, with regards to the classified records, I would say the classified records is more of a, that's not really we're at a record. Well, I guess you can look at it like we've got classified military documents and were they handled correctly or not. That's a huge question. But this case is about interfering with the results of a national election. So I guess in my humble opinion, these charges they're all concerning, but this one really goes to the heart of the Constitution. And, we are supposed to be a representative democracy. We vote for who we want to come into office. And even if there's mistakes in the Electoral College and in the popular vote, we kind of go with what we have and follow those rules until our rules are better. And the rules aren't followed here. And that's why we've got these sections of the code. So I would say this is a pretty momentous, more coffee, momentous moment because we have truly a situation where someone is being alleged and a grand jury has agreed on probable cause of interfering with a federal election. So that's pretty significant. No, I do believe in the Constitution. I have sworn an oath to the Constitution. I most certainly am extremely familiar with the Constitution, and you can feel free to go and check out any of my videos, all the way from the Articles of Confederation to the Declaration of Independence, all the way back to the Mayflower Compact and the Magna Carta. So all of that I have traced and gone through. I think the history and the development of the Constitution is essential. So I am very familiar with the Constitution. Now, the intricacies politically of what's going on here, I have not even asked because that is not relevant to me. I'm looking just at the Constitution and at violations of the United States Code. So that's my main point where I'm coming from. What are all possible consequences if he's found guilty? Well, it sounds like from reading through these different code sections, I think it was 10 and 10, 5 and 10 maybe, I'm not sure. So I mean, I think we were looking at less than 50 years for prison, but I think the ramifications on this, I mean, we could say that this would fall under one of the forbidden crimes under the 14th Amendment that disqualifies someone from running for a position, a government position. You'll have to double check that 14th Amendment to go through that language, but I would say that these would qualify, in my legal opinion, to fall under the portions put into the 14th Amendment that, of course, were passed because of the Civil War and not wanting anyone who instigated the Civil War to be able to run for office. That's why that language was written there. So this, I think, would be something that could be arguable in those situations. Our next president, this is the only reason they are indicting him. They're scared of him running. Well, Jack Sky, for whatever reasons, even if it is political or whatever, people are thinking, this is a criminal indictment from a grand jury. These are criminal law code sections supported by evidence of probable cause. So who the defendant is irrelevant, other than this defendant had the position and the intent to be able to go forward with these charges. Now, again, we've got probable cause. We don't have proof beyond a reasonable doubt, but there's probable cause. I mean, I don't put whomever you want. Put whatever name you want in here. We have a defendant, we have criminal charges, we have proof of probable cause. That's it. I mean, that's it. So finding beyond a reasonable doubt, no, we don't have it. Why they went after him, who cares? The point is, we've got a defendant, we've got criminal charges, we've got evidence. So, I mean, that's just what we've got. And there may not be a finding of beyond a reasonable doubt. That's fine. But a grand jury found based on probable cause. If we start questioning our grand jury's political motivation, I mean, for this case, why not question grand juries for all cases? And then that's a slippery slope into complete and total madness. If our grand juries are no longer reliable, I mean, what does that mean? That's, I'm out of a job. So I would say, I get it. I understand people are frustrated and have a lot of feelings about this particular defendant. I get that. I totally get that. But again, if you cover up this name and you look here at the charges and you look at the evidence, cover up the name. That's what I'm doing. That's how I'm looking at it. So this is just a situation where we have someone who's been charged with 4 different counts of some pretty serious criminal actions. So that's kind of what's going on here. So I try not to be biased, although I think everyone's got some bias to them. It's impossible not to have any bias. I guess the level of these charges or conspiracy against the right to vote is pretty hardcore. So I guess I do have some concerns there. But again, I have taken an oath to the Constitution, and I uphold that oath very wholeheartedly. So talk about the big secret you lawyers keep. Well, I'm sure we've got lots of. There's not just one secret. There's, lots and lots of secrets depending on the lawyer. So I can't speak to that. Yes, of course. Put in whomever you want for a name. Put in whomever you want. Put in. It doesn't matter to me. What I'm trying to explain is this doesn't matter here. The name doesn't matter. What matters is we have a defendant, we have criminal code violations, we have evidence for probable cause. That's it. That's what matters in how I go forward explaining this. That's really it to me. And I think that's really all that is important for criminal law and for education. Other situation, that's really not my purpose here. That's certainly not my goal. So, there are plenty of other places you can find that. So, he isn't above the law or the Constitution. True, no one is. Absolutely nobody is. No one. It doesn't matter who they are. It really doesn't. It shouldn't. It really shouldn't. Of course, resources are different depending on who you are, but Well, and there may be a gag order, but there's no confidential information that's been listed here. And of course, under the Sixth Amendment, we've got a speedy public trial, and transparency within our criminal justice system is essential unless it would hinder the fair trial or due process clause. So we have a lot of that. We should get rid of attorneys. You know, I don't know. I don't think we can get rid of attorneys. We're everywhere. We're like cockroaches. You can't get rid of us. We're just here to stay. But I would say I've got some questions about the attorneys involved in this case and some concerns and extreme disappointment. Because I think all of us take an oath, and an ethics oath, with the exception of 9 people, but we're supposed to follow those oaths. And, when you're going forward and that you are going forward on illegal or things that are against the Constitution or incorrect, there's some questions to be asked there. So I think that there are some questions here, and it's disappointing. It's disheartening for my profession. Absolutely disheartening for my profession. I can't defend their behavior. Even just the probable causeness in this indictment of their behavior, it's atrocious. It is atrocious. What do you think took so long to bring the charges? I think something of this caliber, it takes a while to put this together. I mean, even if you have just to give you an example, if you just have like a mid-level assault, like a bar fight, that's going to take a minimum 9 months to put together. So something of this magnitude with this level and such a huge violating the right to vote. I mean, this to me, it's only been a brief period of time, in my opinion, in the legal world in order to bring this. So the fact that it's out right now, to me, is fast because of the intricacies of these charges. So it's not surprising at all for anyone who is going forward on indictments. How does the 14th Amendment get implemented? Well, if we've got a conviction, then we would go forward and somebody would need to file a claim against it, and there would need to be a lawsuit. We would have to litigate through that 14th Amendment. Let me just pull that section real quick and show it to you. Just so everyone knows what I'm talking about here. Under the 14th Amendment, we have over here. Okay, so it's under Section 3, and it states, no person shall be a senator, representative in Congress, or elector of president, so that's elector, or in vice president, or hold any office, civil or military, under the United States, or under any state who, having previously taken an oath as a member of Congress, as an officer of the United States, or as a member of the state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof. But Congress may vote of 2/3 in each house to remove such disability. So that's the section of the 14th Amendment that we're talking about. Again, and this was passed in order to prohibit anyone who was inciting the Civil War from being able to go forward for an elected position. So the evidence is of probable cause for this grand jury. That is the evidence. Is it evidence beyond a reasonable doubt? No. We don't know that because it's not been put in front of a jury. So the evidence that's here is a level of probable cause for a grand jury. So there is evidence, but are we beyond a reasonable doubt? No, we're not. Would all the evidence be in the indictment, or can they introduce more? Oh yeah, we would never put all of the evidence into the indictment. Well, never is I don't like to use the word never. No, as prosecutors, pick out
you pick out the important parts, you pick out what you need for probable cause, and you don't include the rest. And this is 45 pages long, and so they're just hitting the tip of the iceberg on the evidence that they have. They're going to put forward what they need for probable cause, and that's it. Now, that's not to say the rest of the evidence is hidden away, because it most certainly is not. All of that evidence will be shown to the defendant. He will have full and complete and total access to that, of course. But when it comes to an indictment, nope, we do not. We do not put all of our evidence in. It's just not necessary, and it can kind of clog up the process. So, there were. Why wasn't Hillary indicted when? Well, Hustle Dad, I got no proof that she did anything. You show me some proof and let's indict her then. Let's go for it. But I got no proof of any of that. So this has proof of probable cause. That's it. So if you show me some proof and, let's talk about it. The deleted emails, deleted emails, so what? I don't have any proof. What proof, what charge? Show the proof, show the charge. Even what's the charge? Just pick out a code section and send it to me. I'll look at it. Absolutely. If there's proof of a crime, let's do it. I'm all about that. Let's take care of it. Everyone needs to follow the law. It's just, I don't have any proof. I don't have any information on that. So, that's it. Yeah. Obstruction of justice. There's no, you have to have an act and intent, and that's the criminal equation, what we call the corpus delicti. So we have to have a violation of a particular code section and the intent. So, without those elements, we don't have probable cause. Yeah, we will see. If it comes up, I'll absolutely, join me. I will be back here going through any and all indictments for anyone. I don't care who it is. If it's of this magnitude, my goodness, of course, because I'm just trying to educate. But also, just because one person gets charged with a crime doesn't mean, other people need to be charged with crimes if they, didn't commit the crime. That's not really how the system works. It's just this person has probable cause for these counts. Now, the next person will have probable cause for their counts. It's, apples and oranges. It's not like, well, one side gets charged, now the other side gets charged. That's not really how it works in the system. We just don't. We don't kind of equal out. Okay, now that side got charged. Let's start again with a new set. That's just not how it works. But I get the frustration level, and I hear it constantly. I totally understand where that frustration level is coming from. But again, there's nothing I can do until there's been a charge or an indictment or whatever. We just don't have it. Even Hunter Biden, I've taken a look at that hearing and the proposed plea agreement, and which is not admissible in court, so I don't go through that. But I don't see any problems with what the judge did in that hearing. I thought everything was handled appropriately, and again, under the rules of evidence, we can't use plea agreements or plea negotiations as evidence, and so that's why I've not presented it, not because there isn't any information. So I'm not picking sides here. Just, if there's something, just, call me in. Just pull me in at me. I would be happy to go through any of it. But this is just what I have right now. And I'm trying to just kind of educate here and let people know what's going on, because I think one of the biggest issues, and I think it's shown so clearly in this case, is the misunderstanding or lack of information about how our process works. And I think that's a huge issue. So I'm all about trying to make it clear to as many people as possible. I would show you my license to practice, but I do try to keep private because, as you can see, there can be many problems. I have had a few problems, so I do try to remain a bit private. I'm certainly not here for business or in any kind of a monetary gain, so I'm just here for education. So yes, I wouldn't show my license, but those around me, like the people, like my Supreme Court and various other attorneys that are in charge of my ethical codes, can vouch for me if needed, but my mods have been in and out a bit, so I'm pretty understandable, or I have a pretty wide open field for comments as long as we're not outside of the community guidelines. That's number one. So you watch the whole speech. Which speech, Guy from KC? Which speech? Tell me about it. I haven't seen any speeches. I haven't watched any reporting. I haven't looked into any of that because I don't care to, honestly. I mean, that's for everyone else can enjoy that. For me, I'm just here for the law. So, but yeah, if there's a speech I should look at, you just let me know. I have done trials in the past. I do not currently do that. I have a very low number of people at the moment. I kind of set myself up so that at this time in my life, I would have less on my plate, and I've been very lucky due to well planning. What have you given? Anything on your law? You ramble. You never answer. Where is your license? Where is my license? Carol Henke. My license is in my state, and I choose not to share that information for safety reasons. I do try to be neutral. I don't see any reason not to be. I have no motivation one way or the other. I have no side to pick on me or to pick on to pick on one way or the other. I'm not voting one way or the other in public, so it's something I keep to myself, and I don't feel that I don't choose to try to influence anybody one way or the other. I think it's important. Everybody has their own say in what they want to do. So yes, just make educated choices. Exactly. So I just try to give you information and make that available for people so that you have access, so that people can go and find out for themselves. The indictment is public. Exactly. Yep. It's absolutely. And you can think I'm a phony. That's fine. I know that I'm not every month when I pay my student loans. So So no worries about that. I don't find that offensive at all. Oh, thank you. Thank you kindly. Where will this case be tried? Right now we're in the District of Columbia. So we will see. There's so much that will still be determined coming up in the next couple of days. A lot of that information will be out. This again is just the indictments. I've noticed that this information itself, the full indictment, going through that, I think is just so important that you just see the document itself. I'm not doing any kind of commentary other than just answering questions. So what's the next charge? Wait, let me go back here. What's the next charge if he gets past this? Oh, I really have no idea. I mean, there's lots of different cases going on, civil and criminal. Getting paid by TikTok. Boy, that would be nice. But no, I don't have any kind of monetary gain whatsoever, nor do I choose to. That's just not, it's not important to me. So I've kind of got things sorted. So I'm in a position where I can just share educational information. But after this, I think Georgia's coming up, and I say that based off of the civil case Trump versus CNN, where there was a motion to dismiss on file and a order to dismiss on Friday, just a few days ago. And within that order, he explained that the Georgia district attorney had planned to go forward on charges within the next 2 weeks. So that's why I say that. So I'm not basing that on any reports. I'm basing that on a judicial order. So thank you. Oh, you're welcome. You are welcome. You're welcome. It's a tough time. It's a difficult situation, I think, for the entire country. This is a very difficult moment to have these kinds of charges put out. I don't care who the defendant is, but for anybody, for the co-conspirators involved, these are some pretty significant charges. So, it is pretty distressing. I understand. Whatever happens will be what needs to happen. So, yes, Oh, yes, of course. You're welcome. You're welcome, Megan. Thanks for being here. I appreciate everyone being here. And yes, and Capped, I have already gone through this. It's been a couple hours now. I'm going into my fourth hour, actually. I have gone through this. So right now I'm just kind of catching these last questions on it. I just don't have the voice to go through this again. So I'm just kind of answering questions at this point, just kind of wrapping up here because I am just kind of finishing up making that TikTok money. Where's the TikTok money? Tell me how to get the TikTok money. Someone, please, at me on how to get the TikTok money, because I certainly don't. Sitting president almost pulled off a coup, make me nervous. I don't think nervous completely covers how I'm feeling. I think I'm feeling something beyond nervous. I feel like, I'm having a hard time breathing, actually. It's just so distressing. And again, my whole family's military, and I got married on the 4th of July. It's overwhelming. It's going to take a lot to kind of work through it. So I'll need some time to figure it out. Need some time. Yep. Yes. Oh, sure. Yes, it is. It's a very interesting, difficult time. So, honestly, I wish I would rather this did not have happened. I wish this indictment hadn't happened because I wish none of this evidence and information was true. I wish we didn't have that, but it is. So, now we've got to kind of, as we do in this country, kind of clean up the mess we've got here. So, yes, I'm still at it. I'm going to be, I need to kind of, I'm trying to do closing arguments here as I kind of close down my life. But, well, I try not to gaslight. I think gaslighting is not very useful or helpful for people. So I certainly do my best, as best as I can, to not. So, well, thank you, Andy. I appreciate that. And of course, like I said, it is terrifying. Honestly, it is terrifying. Charges at this level, yeah, it is. It is. And I don't know what's going to happen, but there's a lot more information in here than I had any idea about. And the more times I read it and go through it, the more I think, oh my goodness, wow. And also to know that this is just the tip of the iceberg. This certainly isn't all the evidence that's going to be reserved for trial. So yes, it will be difficult. And I don't think the indictment is a scam. And I understand. I think that's it definitely would make me feel better if it was a scam. But the fact that this is a grand jury indictment is just filed in a court of law at this level. Yeah, it is terrifying. It is. So, yeah, it is. It is very disturbing. I'm not sure the whole system is corrupt, but I think we definitely get problems. And I think we have a lot of things that we have to fix. I think problems present themselves to us in this country, and then we have to figure out how to set it back to rights. So, yes. And I think that, oh no, the grand jury's not bought. I have to speak up for all of our grand juries and all of our juries. No, that's just not how our system works. Here. And if there is an occasional issue with a juror, it's incredibly rare. But have to speak up for these poor jurors that got roped into this, and they had to sit down, listen to this, and then come out with this kind of an indictment. It's going to be very difficult for them for the rest of their lives. This is going to be with them. So, and they're just trying to do their civic duty. It will be tough. It will be tough. They can be presented with misleading info. Absolutely. That is possible. But again, everyone in charge of presenting misinformation to a grand jury would be charged with prison time, and that would be a lot of people. So Again, we've got cross-examination during a trial. That's where we discredit witnesses and discredit evidence and show that it's false. But those requirements aren't required for a grand jury indictment. Those come with the trial. So it is absolutely possible to have that coming forward. So, yes. Yeah. I mean, a grand jury is a pretty significant. So, I think I will go ahead and wrap up now. Again, I've been on for going into my fourth hour here, or third hour. I can't even remember. It was so early when I woke up. But I will have this on my Two to the Ube channel, and which is just my name here that I have on TikTok. So you can go and check it out. None of that, of course, none of this is monetized. This is all just, I'm just sharing this information, explaining it. So this is just for your information. If you choose to look into it, great. If not, that's great too. So it's your call, but you can go find yesterday's live has been posted if you're interested in that. And I will keep everybody posted. I am only, when it comes to this particular defendant, I'm really only posting on any of the federal indictments updates. So the Florida case, I'm really not into the New York case. There are plenty of other people kind of going through the New York hush money case. I did go into the CNN case because that was $475 million in punitive damages. But other than that, this is really it. I'm really just covering kind of the criminal part of it, just explaining indictments and so on, because that's really where my knowledge is within the criminal and evidence part of it. So that's all I've got for you. So if you're interested in that, please stay tuned. If not, thank you anyway for joining me today. I hope everyone has a wonderful day. I'm going to be taking a break from all of this. I've got a lot more in my life other than just this. So yes, you're welcome, VC. Thank you for joining me again. My time to shine. Thank you. I appreciate that. I appreciate your time as well, Teapots. Thanks for coming by. Please feel free to stop by anytime. And thank you again all for your time today. Take care. Wishing everyone the absolute best. And have a great day.